Yes, Your Honor.
Okay. All right, we're back on the record. This is Bear County Court at Law number 6. Judge Wayne Christian, and we're in the middle of our plea and motion to revoke probation docket. Today is the 17th of June, 2021, and it is approximately 10 minutes after 11 a.m. We're now taking up State of Texas versus Brittany Morris, cause 641378. This is a motion to enter adjudication of guilt and revoke community supervision. Representing Ms. Morris is Ms. Alice Warburton. Representing the Bear County CSCD is Ms. Susan Gross, who our minds is still under oath. And representing the Bear County Criminal District Attorney's Office is Ms. Alexis O'Connor. Ms. Morris and Ms. Warburton, I'm now looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference that purports to have both your signatures on it. Ms. Morris, did you sign this document, ma'am?
Yes, sir.
Thank you. And Ms. Warburton, as attorney for Ms. Morris, did you sign this document?
I did, Judge.
Right. The next document I have is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is an adjudication of guilt. Following a deferred adjudication, the defendant has a limited right of appeal, unquote. Is this your signature on this document, Ms. Morris?
Yes, sir.
Okay. And Ms. Warburton, as attorney for Ms. Morris, is this also your signature on it?
It is, Judge.
Ms. Warburton, my understanding is this is an uncontested motion to adjudicate. Is that correct?
Judge, I think we're gonna have to set it for a contested. The state is not understanding what I'm trying to tell them about the drug offenses. The cases have been rejected. There's no evidence that Ms. Morris has done drugs. And furthermore, her failure to report is a combination of my fault and the state's fault because they closed her case and then reopened it. She had a warrant, all of a sudden they had to refile the MTR a few days ago. So any failure to report is kind of my fault and kind of this government's fault, because for a while it showed on the Bear County record system that her case was closed. Probation accidentally terminated her, or at least closed her file. I know it's true. I saw it myself. I'll testify under oath. It said closed. And then all of a sudden she had a warrant again. And I emailed the prosecutor asking, what's this? And she's like, yeah, we don't have an MTR. It went away. We have to refile it. On a criminal trespass? She's paid everything. She's been on for a year. You know, I think I don't know what we're going to do on this because, I think she should just be terminated.
Well, let me back up. Let me back up. I'm just now reading the allegations. State, on Miss Morris' case, you have violated condition number 1, which I'm going to call 1A, that talks about committed offense of possession of controlled substance PG1 on or about November 30th, 2020. And you have violated condition number 1 again, which I'm going to call B, which talks about on the same day committed the offense of prohibited substance in a correctional facility. Now, my understanding is the state's not going to put on any evidence to prove those up. Are you, state? Do you have any intention of doing that?
No, Judge, it was dismissed for further investigation because they don't have labs back yet.
All right. So as far as I'm concerned, Ms. Warburton, I'm not going to consider those two. So that brings us to failed to report for what? 1 month is the only allegation?
That's right, Judge. And she hired me that month. And I will testify under oath as an officer of this court that I looked her up in the system and it said CLS. And I said, are you done with probation? And she said, I thought I was. And I was like, has anyone called you and told you that you're not reporting? And she said, no. And I said, okay, well then I guess you're confused, but it looks like you're finished. And
Well,
I told her that.
Or Susan, let me ask you this. It says she didn't report for November of 2020. Does that mean she hadn't reported since then, or she started reporting again after the month of November 2020?
No, Judge, we have not seen or heard a word from her since September 11th of 2020.
Okay.
And this MTR was filed back in December of 2020. The case was never closed. The only thing I can think of is that you're thinking of her resisting arrest case. That one is closed, but this case has never been closed.
And all I'm saying, Judge, as an officer of this court, when Miss Morris hired me, I looked in the system and I told her, based on what I saw, that her case was closed. And then I asked her, has anyone called you? Are you missing any phone calls? Because normally you know when you're done with probation. And she said, I haven't heard a word. And I told her, well, don't worry about it then. If you feel like you're done with probation and what I'm staring at says that they're done with you, then you don't need to report anymore. If that was not true, then her failure to report is my fault, and I will testify that I was ineffective assistance of counsel. She did not report because I told her she was done, because that is what I saw in the system. So either there was a technical error or some sort of error in the computer, or I made a human error. But she did not just fail to report because she didn't feel like going. I told her she was done. And this has never happened in all my years before. Yeah, I stared at the screen. This caused criminal trespass, CLS. And I mean, unless my eyes were playing tricks on me. And I emailed Miss O'Connor and I said, why does she have a warrant? And she said, well, she had an MTR, but I'll have to ask for them to refile because it's not on file. I have the email.
All right. Well, Ms. Warburton and Ms. O'Connor, what I have in mind is to grant the state's motion based on condition 5 primarily, and take away Ms. Morris deferred, but put her back on probation, on regular probation. Is that something that the defense would think would be equitable under the circumstances, or would you rather do 6 months in jail? What would you rather do?
I think we would rather have her continued on probation, Judge.
Ms. Morris, if I put you back on probation, are we going to have any further problems?
No, sir.
All right, good answer. Alice, do you want to go in a chat room with her and chat about the good, the bad of both sides of this thing?
No, Judge, I mean, she definitely would like to be continued on probation. I would just ask that she be allowed to complete the requirements as they stand. We don't need to intensify probation for criminal trespass. I mean, just let her take the course and be done with it. She's already paid. She's paid off all of the fines.
I think everybody's more excited about the alleged failure to report than pretty much anything else. Now, State, are you telling me that these first 2 cases, 1A and 1B, have been dismissed at this time and no longer pending? Is that correct?
Correct, Judge.
All right. So, State, you want to waive 1A and 1B for purposes of the record? Is
Correct, Judge.
that okay with you, Alice?
That's fine with me, Judge.
Okay. Susan, do you have any further input before I rule on this thing?
Judge, I haven't given you any of my input yet.
Oh, Susan, would you please give us all your input at this time?
Yes, Your Honor, I'd be more than happy to. Ms. Morris has performed very poorly on probation in that she has not reported since September the 11th of 2020, and she missed her last 5 months of reporting. Her case is paid in full. She did complete all of her community service hours. She had 2 negative drug tests. She failed to submit to drug testing on 3 occasions when she was ordered to drug test. She has not done the stress class. The case is expired as of February 17th of this year. She has a prior arrest for possession of marijuana, 2 to 4 ounces, and a resisting arrest. And then, of course, she's on for the criminal trespassing. She did have 2 new arrests for felonies, which was possession of a prohibited substance, penalty group 1, 1 to 4 grams, and a prohibited substance in a correctional facility, but those have been rejected at this time for further investigation. Her officer is recommending a 1-year extension, weekly drug tests, and cat snip.
And Judge, as the state has waived 1A and 1B, and there are no drug allegations at this time, weekly drug testing and cat snip are inappropriate and are not tailored to the MTR, right? Because the state has waived those allegations. And so, case law is very clear on that. So I would just ask that Ms. Morris be continued.
And Judge, this is the 3rd violation report and her 2nd in-person MTR.
Is this a Class A or a Class B?
It's the Class B, Judge.
One would think I would know that, wouldn't one?
Criminal trespass is practically a class C.
If it's in a habitation, it's an A. This is just private property, so.
Yeah,
Allegedly.
yes, allegedly.
And Miss Morris, hang around after the judge gets talking because I need to give you some instructions.
All right.
Susan, what was the original fine on this case?
$400, Your Honor.
Susan, when's the last time you saw me continue anybody on probation that we hadn't seen in a while?
Oh my gosh, it's been years now, Judge.
There you go. Just giving Miss Warburton a rah-rah here.
And I appreciate that.
Okay. And I assume since the state has waived conditions 1A, or what I'm saying for the record, condition 1A and 1B, when we have number 5 left, which is failure to report basically since the month of November 2020, and 15 that she hadn't completed the APSE stress education program. And Alice, she's pleading true with an explanation of both of those. Would that be accurate?
Yes, and with the true to the explanation is that I was ineffective assistance of counsel on the failure to report.
Okay, I'll send that in to the state bar when we're finished, no problem.
Judge, also at the beginning, can we please clarify because Ms. Warburton requested a contested MTR. So is this contested or no?
It is no longer contested now that the state is willing to waive the drug allegations. Then those are no longer part of the MTR and are stricken, then we're no longer contested.
Fair enough. All right. Ms. Morris, in clause 641-378, the court accepts your plea of true with an explanation to conditions number 5 and 15 on the motion to enter adjudication of guilt and revoke community supervision. I grant the state's motion to revoke your deferred adjudication probation. I find you guilty of the offense of criminal trespass on private property. I sentence you to 6 months in the Bexar County Jail, probated for 1 year. A $400 fine plus court costs. Was there community service on this, Susan, early on the original deal?
Yes, sir. She had 36 hours and she actually completed 40.
Wonderful. 36 hours of community service. The Community Alliance for Traffic Safety New Intervention Program, which is an outpatient drug program. Weekly UAs that Ms. Warburton objects to, but if she shows me 4 clean weekly UAs, Alice, I'll put her back on monthly, just like everybody else. But she's got drug allegations involved in this stuff, and we need to make sure we don't have any further problems. I'm going to give her 30 days in the Bexar County Jail as a sanction, but I'm going to hold it in abeyance. So if there are any further problems, she's got that over her head. Otherwise, that will not come into play. She gets credit for any monies paid or any classes completed. Did I do any bad things to her on bond? Probably I did.
I
Is she
think
on
she just
GPS?
has- no, I think she just has a warrant right
Yes,
now.
she has a warrant, Your Honor.
Okay. Recall warrant, which should be recalled by operation of law. Okay, what did I miss, Susan?
That's all. I just need to give her and her attorney some instructions.
All right, Alice, do you have any questions?
I do not judge.
All right, Ms. Morris, do you have any questions?
No, sir.
Your attorney just saved you. You might want to keep her around for a while. All
Thank you.
right. Go ahead, Sue.
All right, Ms. Morris, the probation department will be contacting you most likely by email, but it may be by text or phone or something because you're basically starting probation all over. So you have to go through the orientation process again. If you don't hear from them by, let's say, noon on Friday, you need to call this number. Alice, you might want to write this down because she probably doesn't have a pencil.
Okay.
210, oh, you do. 335-7446. That is the intake desk. Okay, so if you don't hear from them by like noon on Friday, give them a call. Let them know that you were put on probation and you need an orientation date. Okay, any questions?
The other thing that I need to tell you is I need to send first to your attorney and then to you a new application for probation with a data sheet. And that will be sent as soon as I am off Zoom. So that needs to be done as soon as possible so that the clerks can send it to probation. So that way they can schedule your orientation. Okay?
No problem, Pat. Just everybody email me what
Yeah, I
needs to
will.
be done.
I'll send it like I said.
Brittany, if you have any questions, let me know. And then I have an 11:30 plea. May I be excused? Your Honor.
I'm sorry, that's all good.
Okay, thank
All
you, Judge. Brittany, if you have any questions, ask Susan now. And then if you still have questions, call or text me later, okay?
Thank you.
Okay, do you have any questions, Ms. Morris?
I do not.
Okay, your officer will be staying the same. It'll be Miss Wilcox. And, but you'll be going through the orientation process again. So good luck to you. You're free to go.
Thank you. Thank you.
Bo, are you ready to proceed on Mr. Delgado? You've been very patient with us all day.
Yes, sir.
All right.
I think mostly my fault.
Nah, hardly. Squad 641-378, Data Texas versus Anthony Delgado. This is a first amended motion to revoke community supervision. Representing the defendant is Mr. Bo Woods. Representing the state is Ms. Alexis O'Connor. Representing the Bexar County CSCD is Ms. Susan Gross, who I remind is still under oath. First document I need signatures identified on is entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference. Mr. Delgado, is this your signature on this document, sir?
Yes, Your Honor.
And Mr. Woods is also your signature as attorney for Mr. Delgado.
Yes, Your Honor.
Mr. Delgado, the second document that apparently has yours and your attorney's signature is entitled Trial Court Certification of Defendant's Right of Appeal, which is marked, quote, is a revocation of the defendant's community supervision, and the defendant has the right to appeal the court's actions, revoking the community supervision, but not the underlying conviction. Is this your signature on this document, Mr. Delgado?
That's my lord too. Yes, Your Honor.
Thank you. And Mr. Woods, is this also your signature on this document?
Yes, Your Honor.
Mr. Woods, my understanding is this is uncontested motion to revoke probation. Is that accurate?
Yes, sir.
Okay. At this time, Mr. Delgado, on the first amended motion to revoke community supervision, how do you plead, sir?
True.
True, sir.
Okay. Ms. Gross, would you please advise the court and the parties of the status of Mr. Delgado's probation?
Yes, Your Honor. Mr. Delgado has been reporting as directed. We last saw him on May 13th of 2021. He's paid $555 towards his fees. He has a balance of $224. He is currently delinquent $174. He's completed 15 of 40 hours of community service. He has had 2 positive drug tests for marijuana. He's failed to submit to drug testing on 1 occasion. This is his first violation report, first MTR. His criminal history includes 1 prior arrest for criminal trespassing on private property. His officer is recommending that he be continued on probation and that we add weekly drug testing.
That's our
Okay,
agreement.
Bo,
Judge.
go ahead.
That's our agreement, Judge. This young man's 31 with 3 small children, has a good job, but he's looking at trying to go into air conditioning repair work or installation. So he's got a good job opportunity, and we would like to give him that opportunity, Judge.
Mr. Delgado, if I give you your analysis test today, you're going to be positive for marijuana?
Sir, I've been in jail for about 8 days, so I don't know if it's out of my system completely.
Okay. I got it. State, do you agree with Mr. Wood?
Correct, Judge.
Mr. Delgado, in clause 641-378 on the first amended motion to revoke community supervision. I accept your plea of true to all conditions on the motion to revoke community supervision. I deny the state's motion to revoke your probation. or you continued on probation with all prior requirements with a sanction of 10 days, Bear County Jail, credit for time served, judgment satisfied. And adding and amending your conditions to put in weekly UAs, starting as soon as you get out, which hopefully will be today or tonight. And you start coming up positive immediately, we know that you've been using, but if it's 30 days from now, if I still get a positive UA for marijuana, you're gonna have to call Mr. Woods again because you're gonna be in deep tension. Substantial compliance in all areas. You need to work on community service. Has he done any community service, Susan, that you know of?
Judge, he's done 15 hours out of 40.
That's good. And I'm going to add catnip outpatient drug because we've had multiple marijuana issues. And you can catch up on your money. All that within 30 days will be all good. All right, let me go over it again. Mr. Delgado, the court accepts your plea of true to all conditions on the first amended motion to revoke community supervision. I deny the state's motion to revoke your probation, or you continued on probation with all prior requirements with a sanction of 10 days, Bear County Jail, credit for time served, judgment satisfied. Altering in many conditions, adding weekly UAs and requiring substantial compliance in all other areas within 30 days, and adding the Community Alliance for Traffic Safety New Intervention Program outpatient drug program. Susan, you got anything else that we need to do to help Mr. Delgado?
No, sir. Just Mr. Delgado, you should be receiving an email from your officer with your amended conditions, probably within the next 24 hours. You need to sign those conditions and send them back. And you need to confer with your officer as far as your next report and getting the referral for CAT-SNP, okay?
Yes, ma'am. Can I ask one question?
Sure.
The drug program, what is that gonna have to do with, or where am I gonna have to go for that?
Your officer will give you the referral on where you need to go. It's an 8-week class. You're gonna go once a week for 2 hours at a time.
Okay, and I do have a job and I do work a lot, so
Well, you can either do the program or you can do your jail time.
oh no, I'd rather do the program.
That's kind of what I thought. So confer with your officer and she will give you the information on where you need to go to do that program.
Yes, ma'am.
Okay, and then she is also going to be setting you up on the IVR drug call line. You're going to call it every morning and it's going to tell you whether or not you have to provide a sample that day.
Yes, ma'am.
All right. Any other questions?
No, ma'am.
All right.
And
Good luck to you, sir. Thank you both.
Mr. Delgado, the judge ordered 10 days in jail, but he also said judgment satisfied. That means you'll be released today. You do not owe any more time in jail. You'll be released tonight. You'll get out tonight.
Yes, thank you, Mr.
Right? Thank you. Thank you, Judge.
You bet. Susan, does CATS have night classes at all on any of this stuff?
Yes, sir, they do.
All right, so that might be another option, Mr. Delgado. They may have night classes. I don't know where you work or what your work hours are, but that might allow you some time to do that. All right. Good luck, Mr. Delgado. Thank you, Bo.
Thank you, Judge.
All right. We got Mr. Arguelles with us. Ready on Miss Megan Howard.
I'm ready, Judge.
All righty. This call is 491-802, State of Texas versus Megan Howard. This is a first amended motion to enter adjudication of guilt and revoke community supervision. And Pat, I do have somewhere a waiver, consent to motion to revoke hearing by video conference on Ms. Howard, do I not?
You sure do. You should be.
Okay.
They were,
At this time, Ms. Howard, I'm looking at a document entitled Defendant's Consent to Motion to Revoke Hearing by Video Conference, which alleges to have both your signature and your attorney, Mr. Arguelles' signature on it. Is this your signature on this document, ma'am?
Yes, sir.
And Mr. Arguelles as attorney for Ms. Howard, is this your signature on this document, sir?
It is, Your Honor.
And let's see, the next document I have is a trial court certification of defendant's right of appeal. And in this particular case, it would be marked is an adjudication of guilt following a deferred adjudication, and the defendant has a limited right of appeal. Is this your signature on this document, Ms. Howard?
Yes, sir.
And Mr. Arguelles, as attorney for Ms. Howard, is this also your signature on this document?
Yes, Your Honor.
Mr. Arguelles, is this an uncontested motion to revoke?
Yes, Judge.
Ms. Howard, on the first amended motion to enter adjudication of guilt and revoke community supervision, how do you plead, ma'am?
True.
All right, Ms. Gross, I remind you, you are still under oath. Would you please advise the court and the parties of the status of Ms. Howard's probation, please?
Yes, Your Honor. Ms. Howard has performed very poorly on probation in that she only reported 3 times, and we have not seen her since July 24th of 2018. She paid $525 towards her fees, has a balance of $573. She completed 12 of her 24 hours of community service. She had 1 negative drug test and 2 positives for opiates. We have no record of her theft class having been completed. This is her first violation report, first motion to revoke. The case expired on October 8th of 2018. She has no criminal history, and her officer is recommending that if she provides proof of a class and pays in full, that her case be terminated unsatisfactory.
Well, you can pass on to the head of the CFCD that that's a ridiculous recommendation under the circumstance. Tell him
Yes,
I
Your Honor.
said so. So that being said, Ms. Howard, do we have a heroin problem? What is our drug issue that we're dealing with here?
Your Honor, it's not a heroin problem. She is actually prescribed the opiates in this case, and Ms. Howard can get more into
Hey,
detail.
Mr. Arguelles, go and explain that to me, because obviously that's got my attention.
Yes, Judge. Ms. Howard was letting me know that she is actually prescribed some of the opiates. She can get into more detail to the court if you would allow her, Judge.
Sure.
Ms. Howard?
Yes, sir. I have a herniated disc in my neck, and then I have arthritis real bad, and I've been prescribed opiates for the past about 2 years.
Have you ever used heroin before, ma'am?
No, sir.
Okay.
Never.
Did you provide a copy of the prescription for these prescription drugs to your probation officer so that they understood what was causing this positive?
Well, at the time, I wasn't being prescribed them. Is the problem.
So where were you getting the opiates at that time that caused you to become positive?
I was buying them, Your Honor.
And what kind of drug was it you were taking for pain, I guess?
Tramadol.
Susan, does tramadol test positive for opiate?
I was taking tramadol, and then I think I took 1 hydrocodone at one point.
Hydrocodone.
Yes, sir.
Yes, Judge, it can.
Okay, and hydrocodone obviously will test positive for opiate.
Absolutely.
I got you. All right, that doesn't explain why we stopped reporting. Do you have an answer for that one for me, Ms. Howard?
I was just scared because I was told by my officer that I came up dirty, and I was scared that I was going to get arrested right then and there.
Well, that was probably a valid concern at the time.
Judge,
Yeah,
we do have some prescriptions on file, but the 2 drugs that she provided us a prescription for, neither of them are going to be testing positive for opiates.
Ms. Howard, are you working? Do you have children? What's going on with you, notwithstanding this case?
Yes, I'm a cashier at a restaurant, and I have 2 children that I raised by myself.
Okay, Mr. Arguelles, I'm kind of between a rock and a hard place. I've still got some serious drug involvement in this case. And the textbook solution is inpatient drug rehab, which nobody really wants to go to, as you're well aware. I've got status substance abuse treatment facility for the minimum time of 120 days, or I've got revocation in jail. I'm thinking the sheriff is giving 2 for 1 right now on jail sentence.
That might be the case, Your Honor. Right now, I don't think that Ms. Howard actually has a drug problem. Your Honor, we would be asking the court if we can sentence her to the jail. She does have 14 days in, Judge, and we would be asking for a judgment satisfied in this case.
Okay. And state recommendation?
Sorry, Judge. I don't know if she's gonna be able to pay that fine that probation recommended. but she does have 15 days in, so I would recommend JSATing, revoking and JSATing her.
Ms. Howard, the court in cause 491-802 accepts your plea of true to all conditions on the motion to enter adjudication of guilt and revoke community supervision with an explanation. I grant the state's motion to enter adjudication of guilt and revoke your community supervision. I find you guilty of the offense of theft, $50 to $500. I sentence you to 6 months in the Bexar County Jail. Assess a $2,000 fine plus court costs, credit for time served, time and money to run concurrent. If she changes her mind and is interested in inpatient drug rehabilitation, I've got 30-day continuing jurisdiction over this case. And if that were the case and she wanted to volunteer for that, she would go back on probation, she wouldn't be revoked, and she'd go to SATIC. It's going to take probably plus or minus a month for her to get into SATIC. Would that be accurate, Susan?
Yes, Your Honor.
Anything further from the state or the defense on Ms. Howard?
Nothing further, Judge.
All right. Good luck, Ms. Howard. Thank you, Mr. Arguelles.
Maybe put in a breakout room with my client, Judge.
I'm sorry?
Maybe put in a breakout room with my client.
Oh, absolutely. Sure.